Imagine walking into a lawyer's office, sitting down at this big oak desk, and you sign a legal binding title deed where the new, permanent, incontestable owner of your multi-million-dollar estate is, well, it's God.
Yeah, it's a wild concept.
Right. You can't ever sell it. Your kids cannot inherit it. You absolutely cannot borrow against it. It's just locked away from human ownership until the end of time.
It really, it completely shatters our modern Western-centric concept of property rights, doesn't it?
Oh, totally.
Because we are so accustomed to the idea that ownership means, absolute dominion, the ability to alienate, to liquidate, to transfer it whenever we feel like it.
Yeah, we expect a remote control for our assets. We want to be able to hit pause or rewind.
Exactly. But when you step into the really complex, philosophically dense world of Islamic family law, that neat binary concept of ownership is just dismantled.
It's completely redefined.
Right. You are looking at a legal framework that entirely redefines what it means to hold wealth, what it means to surrender it, and how we are legally permitted to leave a legacy.
Which brings us to why we're all here. Welcome to you, the curious learner joining us today. You're here for another deep dive tailored to explore the fascinating mechanics of property, charity, and succession under Islamic jurisprudence.
And we've got a lot of ground to cover.
We really do. Today, we are dissecting two monumental pillars of this legal architecture. First is Waqf, which is the irrevocable dedication of property to the divine, and second is succession, which involves these highly constrained, mathematically rigorous rules dictating how personal wealth is passed down to mortals.
And we need to establish right out of the gate that we aren't just looking at, a dry list of statutes or some historical relic.
Right, it's not just a textbook.
No, not at all. If you approach this simply looking to memorize rules, you're going to miss the profound social engineering at play here. These are really sophisticated frameworks. They're designed to balance the tension between individual agency, familial obligation, and community welfare.
It's basically law functioning as applied philosophy.
That is the perfect way to put it, yeah.
So let's jump right into the deep end with Waqf. Because if Waqf controls what we permanently surrender, we really need to understand the mechanics of that surrender. Like, what does it actually mean, legally speaking, to transfer property into the domain of the divine?
Well, the term Waqf literally translates to detention or tying up.
Tying up, okay.
Right. In the legal context, it's the permanent dedication of property by a Muslim for purposes recognized by Muslim law as religious, pious, or charitable.
But how is that different from, say, a regular charitable trust?
The mechanism is what really sets it apart.
Yeah.
In a modern secular trust, you transfer the legal title to a trustee and they hold it for a beneficiary.
Right. The trustee technically owns it on paper.
Exactly. But when a Waqf is validly created, the ownership is completely extinguished from the founder, who is called the Waqif, and is legally recognized as transferring directly to God.
Wow. Okay, so it's essentially an irrevocable purpose trust where the ultimate beneficiary is humanity, but the settler just completely relinquishes all legal standing.
Yes.
It's like a cosmic lockbox. Human hands can reach in to distribute the fruits of the property, the income, but human hands can never again claim the tree itself.
A lockbox is the perfect way to conceptualize it. The corpus of the property is arrested.
Arrested. I like that word for it.
Yeah, because the owner is divine, the property is inherently inalienable. I mean, it cannot be sold, it cannot be gifted, it cannot be attached by creditors, and it certainly cannot be inherited by your heirs.
But the law doesn't just let you casually declare, I give this building to God and walk away, right? That would be an administrative nightmare.
Oh, absolutely. The jurisprudence acts highly defensively here. There are 5 non-negotiable essentials to make this cosmic transfer valid.
Okay, let's walk through those. What's the first one?
First and foremost is absolute permanency.
So no take-backs?
None. There is no such thing as a temporary Waqf. You cannot say, I dedicate the income of this commercial plaza to the orphanage for 20 years and then it reverts to my estate.
Right, because then it's just a regular lease or a standard trust.
Exactly. That is a different legal instrument entirely. A Waqf is forever.
Which immediately creates a massive threshold for intent. I mean, you have to be absolutely certain you want to do this.
Yeah.
What are the other essentials?
Second, the purpose must be religious, pious, or charitable.
Makes sense.
Third, the Waqf must have the legal capacity, meaning they must be a Muslim of sound mind, a major, and crucially, they must actually own the property free and clear at the time of dedication.
Oh, wait, so you can't dedicate like heavily encumbered property?
No, you cannot.
So I can't take a building with a massive mortgage, give it to God and say, hey, the divine will take over the payments.
Precisely. You cannot transfer a defective title to the divine. You can't give away the bank's collateral.
That's a great point. Okay, what's the fourth essential?
Fourth, the property itself must be tangible and capable of use. Historically, this meant immovable property, land, buildings, orchards.
Right, stuff that lasts.
Yeah. You couldn't easily make a waqf out of consumable goods or highly volatile assets. Although modern jurisprudence has expanded to include shares and certain movables, provided the corpus can be maintained.
Okay, and the fifth?
And fifth, the declaration must be crystal clear and irrevocable.
The strictness of these essentials, requiring clear, unencumbered, tangible property and absolute permanency, it really feels like it's anticipating a specific problem.
What do you mean?
Like it's anticipating the natural human instinct of heirs trying to claw back the wealth later on.
Oh, it completely anticipates human greed.
Right.
Imagine a wealthy patriarch creates a walk-up using prime urban real estate. 2 generations later, the area is gentrified, the property value absolutely skyrockets, and his grandchildren look at it and say, we could be billionaires if Grandpa hadn't given this away.
Let's find a loophole.
Exactly. Let's find a loophole. The strict essentials. The undeniable clarity of the transfer build an impenetrable jurisprudential wall around the charity. It protects the community's future access against the inevitable regret or greed of the founder's descendants.
It's basically institutionalizing philanthropy by completely divorcing it from human frailty.
Yes.
So how is this wall actually constructed in practice? What are the mechanisms for creating a waqf?
There are 3 primary avenues. The first is inter vivos, which is just an act between living persons.
Right, while you're alive.
Yeah. A living waqif makes an explicit declaration. Now, while an oral declaration is historically recognized if the evidence of intent is irrefutable, in the modern administrative state, this is almost universally done through a formally registered deed.
Well, yeah, that makes sense. The evidentiary burden of proving an oral permanent transfer of real estate would be a total nightmare today.
Absolutely. You want it on paper to avoid exactly the disputes we just mentioned.
Okay, what's the second mechanism?
The second is testamentary by will, taking effect upon death. But here we encounter a massive structural limitation in Islamic property law.
Oh, the fractional stuff.
Right. You can only create a waqf by will for up to 1/3 of your net estate.
Only 1/3. Wow.
Yeah. If you wish to dedicate half your wealth or your entire estate to God via a will, you cannot do it unless your legal heirs explicitly consent to the dedication.
Yeah, they have to consent after your death.
Yes, after your death.
We are absolutely going to dive deep into that 1/3 rule when we get to the succession part of this deep dive, because the tension between charitable intent and family obligation is, I think, arguably the core philosophical conflict in this entire legal framework.
It really is the balancing act of the whole system.
But before we get there, what is the third method of creation?
Creation by usage.
Usage.
Yeah. This is where a property has been used for a religious or charitable purpose for such a long, uninterrupted period that the law infers a waqf was created, even if the original founding documents are just lost to history.
It's essentially the doctrine of adverse possession, but for the divine.
That's a great analogy.
The community's continuous use of a graveyard or a prayer space literally speaks the institution into legal existence over time.
Exactly. The historical reality supersedes the lack of paperwork. Now, when we look at the kinds of waqf created by these methods, we see a fascinating categorization.
Okay, let's break those down.
There's the public waqf, which is pretty straightforward. A mosque, a public well, a hospital. It is immediately and directly for the benefit of the public.
Right, very clear-cut charity.
But then we have the private waqf, known as Waqf al-Awlad.
Okay, and this is where the definition of charity gets highly complex, right?
Oh, very much so.
Because a Waqf al-Awlad is a dedication where the initial beneficiaries are the founder's own family and descendants.
Yes.
The property is locked up, the corpus is preserved, but the income goes to the kids and the grandkids. So my question is, how does locking up wealth for your own bloodline qualify under the mandatory essential of a religious, pious, or charitable purpose?
This specific mechanism caused massive jurisprudential friction, particularly during the British colonial period in India.
Oh, really? What happened?
Well, the British Privy Council looked at Waqf al-Awlad and essentially said, this isn't charity. This is just a clever legal fiction to bypass the rule against perpetuities.
Huh. You're just hiding your money.
Exactly. They thought, you are just trying to keep your estate intact and cheat creditors by slapping the word God on the deed. They fundamentally misunderstood the Islamic worldview on wealth.
Because in Western common law, if a trust primarily serves a private family line in perpetuity, it violates public policy. It creates this endless monopoly of dead-hand control.
Precisely. But in Islamic jurisprudence, preventing your own descendants from falling into destitution and becoming a burden on the public purse is considered a fundamentally pious act.
Like,
Charity literally begins at home. The law views the sustenance of one's lineage as a moral obligation.
but there has to be an ultimate public benefit, right? It can't just be a family slush fund forever.
Correct. The legal linchpin that makes a Waqf Laws valid is the requirement of ultimate reversion.
Reversion.
Yes. The deed must unequivocally stipulate that upon the eventual extinction of the founder's family line, whether that takes 3 generations or 300 years, the entire benefit of the property permanently reverts to a recognized public charity.
Like feeding the poor or funding education.
Exactly. It marries the natural human desire to provide for one's children with the ultimate, inescapable destiny of public good.
That is a brilliant harmonization of human instinct and civic duty. You get to take care of your kids, but ultimately society wins.
Yeah, it's very elegant.
But the gravity of this transfer brings us to the ultimate rule. The no-takesies-backsies doctrine. Let's look at the human drama behind the principle of irrevocability. We have case law like Abdul Ghaffur v. State of Bihar that really hammers this home.
The irrevocability principle is absolute. Once the declaration is made and the legal requirements are met, the Waqf loses all rights of ownership instantly and forever.
Okay, let's play out a hypothetical here, because this must have happened countless times in history.
Go for it.
Let's say I'm a wealthy merchant. I create a Waqf, dedicating a massive commercial complex to fund a local hospital.
Okay, very noble.
Right. But 5 years later, an economic depression hits. My merchant fleet sinks, my business collapses, and I am facing absolute bankruptcy. I'm ruined.
Okay.
So I look at that commercial complex I gave away, which is generating massive income, and I file a petition to revoke the Waqf, or, at least amend it so I can take a small percentage just to survive. What happens?
The court will reject your petition outright.
Outright? Even if I'm starving?
Your economic change of circumstance is completely irrelevant. The property is no longer on your ledger. The courts, enforcing the principles seen in Abdul Ghaffur and centuries of jurisprudence, will tell you that you cannot alter it, you cannot cancel it, and you cannot touch the corpus.
Wow.
The transfer to the divine is absolute.
Which poses a massive pragmatic dilemma when you think about the day-to-day operations. Well, we have a physical asset, a building that needs a new roof, tenants who need to be evicted, property taxes that need to be paid. But the legal owner is God. We have this massive fiduciary void. You need an earthly CEO to manage the divine portfolio.
That's right, and that earthly CEO is the Mutawalli.
In Mutawalli?
Yes. The law creates the office of the Mutawalli to serve as the manager, the superintendent, or the caretaker of the Waqf property.
But the distinction between a manager and an owner can get very blurry in practice, especially over generations.
Very easily, yes.
Because if a Mutawalli is collecting the rent, signing the leases, and paying the bills, they look exactly like a landlord to the outside world.
Which is exactly why the jurisprudence draws a hyper-vigilant line to prevent the Mutawalli from assuming the posture of ownership.
How do they enforce that line?
Well, in the landmark Supreme Court case, Syed Emlan Sali Labai v. Mona Hanifa, the court exhaustively clarified this legal status.
What do they rule?
They stated that the Mutawalli is a manager and never the owner. The property does not vest in them in any capacity. They are merely a conduit, an administrator executing the specific terms of a divine trust.
So they are essentially the trustee of an orphaned corporation.
Sort of, yes.
Their fiduciary duty is arguably higher than a corporate CEO because the ultimate shareholder is infallible and the beneficiaries are incredibly vulnerable.
That's a really good way to frame it.
So who qualifies for this immense responsibility? Do you have to be a religious scholar?
The qualifications are actually surprisingly pragmatic. The law demands competence over pure theology. A Mutawalli must be a major, of sound mind, and possess the administrative capability to actually manage the assets.
Okay, so just basic competence.
Right, and they must be honest and reliable.
Does the Mutawalli have to be a Muslim?
Fascinatingly, no.
Really?
Yeah. While it is strongly preferred, the law recognizes that the role is primarily administrative.
Wow, I wouldn't have expected that.
As long as the non-Muslim Mutawalli can faithfully execute the duties without violating the religious nature of the institution, for instance, if the duties only involve collecting rent and distributing it to a hospital, rather than, say, leading prayers, they can legally serve.
That really underscores that the role is one of management, not spiritual leadership.
Exactly.
How does the succession of this role work? Does it become a hereditary fiefdom, like father to son?
It can if the original Waqif explicitly designed it that way in the founding deed.
Oh, so the founder has the say.
The Waqif has the absolute right to appoint the first Mutawalli and lay down a strict line of succession.
But what if they don't? What if the deed is silent?
If the deed is silent, or if a Mutawalli dies without appointing a successor on their deathbed, the power to appoint falls to the court or the statutory Waqf board. And sometimes well-established local customs dictate the succession.
Okay, but the law doesn't just hand them the keys and look away, right? It places the Mutawalli on an incredibly tight legal leash.
Oh, incredibly tight.
Let's look at their powers, particularly regarding leasing, because this is where the law's defensive mechanism against the manager really shines.
Yes. The Mutawalli has the power to lease out property to generate the income necessary for the charity. But the law is terrified of the property becoming encumbered.
So they put a cap on it.
A very strict cap. For agricultural land, a Mutawalli can generally only grant a lease for a maximum of 1 year.
1 year.
And for non-agricultural land, like a commercial shop, the lease is strictly capped at 3 years.
Okay, any modern commercial developer would laugh at a 3-year lease.
I absolutely would.
How do you attract a serious business tenant if you can't guarantee their tenancy long enough for them to recoup their capital investment? It just seems economically inefficient.
It is economically inefficient by modern capitalist standards, but it is deeply protective by jurisprudential standards. The law caps these leases to actively prevent tenants from establishing claims of adverse possession or permanent tenancy rights.
Ah, I see. It forces the Mutawalli to constantly reassert the Waqf's dominion over the property.
Precisely.
Because if a tenant is sitting on prime real estate for 30 years with a passive Mutawalli, they start treating the property as their own. The short lease forces a legal confrontation.
Yes, it resets the clock.
It prevents the Waqf from losing practical control of the asset through managerial neglect. But wait, what if the Mutawalli genuinely needs a longer lease for a major development? Like building a new wing on a hospital, what do?
They cannot do it unilaterally. They must formally petition the court or the Waqf board, present the economic rationale, and obtain explicit judicial sanction.
So there's a safety valve.
Yes. The court acts as the ultimate guardian of the divine property, ensuring the long lease actually benefits the charity, not just the manager or the tenant.
And this oversight isn't just theoretical case law anymore, right? It has been heavily codified and modernized. The syllabus for our deep dive directs us specifically to the Waqf Act of 1995 and its subsequent amendments.
Yes, the act is crucial here.
This statute basically acts as the regulatory teeth keeping the Mutawallis in line.
The Waqf Act of 1995, especially as it was overhauled by recent amendments, created a massive statutory framework to standardize administration across the entire country.
What are the key sections we should look at?
Well, it explicitly codified what were once common law duties. Section 38 outlines the strict parameters of the Mutawalli's powers. And then Section 47 elevates the maintenance of detailed financial accounts from a moral expectation to a strict, auditable statutory requirement.
Meaning you can't just keep the books in your head anymore.
Exactly. You have to prove where every penny goes.
And crucially, the Act revolutionized how disputes are handled by establishing specialized Waqf Tribunals.
That was a game changer. Before the tribunals, if a Mutawalli was accused of corruption or if there was a dispute over whether a property was actually a Waqf at all, it would get bogged down in standard civil courts for decades.
Right, because civil courts are overwhelmed.
The creation of specialized Waqf tribunals under the Act rips these disputes out of the slow civil system. These tribunals have exclusive jurisdiction to determine the nature of the property and adjudicate administrative disputes.
Creating a much faster, more specialized mechanism to protect the assets.
Exactly.
So if a Mutawalli is failing, if they are embezzling funds or just letting the property fall to ruin, they can be removed. I know the case of Ali Ahmed v. Bashir Ahmed deals directly with this.
Yes. Now, a Mutawalli does have rights. They are entitled to their agreed-upon remuneration, but they have absolutely no absolute tenure.
They can't just coast forever.
No. As demonstrated in Ali Ahmed, if there is proven malfeasance, breach of trust, willful mismanagement, or physical or mental incapacity, the Waqf board or the tribunal will not hesitate to strip them of their position.
The fiduciary duty to the divine owner just utterly eclipses any claim to job security.
It has to. The stakes are too high.
This entire relationship between the Mutawalli and the property beautifully echoes the concepts of bailment. The jurisprudence draws parallels to amanat, meaning trust property, and wadiya, meaning deposit.
It's a striking parallel to modern corporate fiduciary duty, really. In bailment, if you entrust an asset to someone for safekeeping, they must exercise reasonable care, they cannot use it for personal enrichment, and they must execute the purpose of the deposit.
Right. You give your coat to the coat check, they can't wear it out to dinner.
Exactly. The Mutawalli is essentially the bailey of the divine. They're handed the keys to the kingdom, but they are strictly forbidden from sitting on the throne.
That is a remarkable system of checks and balances designed to enforce permanence. But let's make a major thematic shift here.
Okay, shifting gears.
We have spent this first half exploring the unyielding permanence of Waqf wealth locked away forever. Let's pivot to the other side of the legal syllabus. Succession.
Right, mortal wealth.
Yes. What happens to the wealth that isn't given to God? What happens to the personal property of a mortal when they die?
Well, we transition from a world of absolute dedication to a world of intense mathematical constraint and familial obligation.
Math, everyone's favorite subject in law school.
Muslim succession law is a highly structured, fractional system designed to disperse wealth rather than concentrate it. And the first shock to the system for those accustomed to Western law is the concept of wasiat, or the will.
Right, because under secular or common law systems, we kind of worship at the altar of testamentary freedom.
We really do.
If I own an estate and I decide on my deathbed to leave 100% of it to my favorite charity or my best friend or my pet cat, intentionally disinheriting my children, the law generally says, it's your property, do what you want.
Under Islamic law, that absolute testamentary freedom just does not exist. Your power to write a will of wasiat is strictly capped at a maximum of 1/3 of your net estate.
Okay, let's define net estate first, to be precise, because it's not just the total amount of money in the bank.
No, it's not. When a Muslim dies, before any inheritance is calculated, the estate must first be applied to 4 specific things in absolute order of priority.
What's the first priority?
First, payment of funeral expenses.
Okay.
Second, payment of all legitimate debts. What remains after those obligations are cleared is the net estate.
And of that net estate, you are legally forbidden from willing away more than 33.3% to non-heirs.
Correct. The remaining 2/3, the absolute minimum, is legally locked in and must be distributed to your Quranic heirs according to fixed mandatory fractions.
Is there any exception to that?
The only possible way a will can exceed the 1/3 limit is if the legal heirs explicitly give their consent to the excessive bequest after the testator has died.
Why, after the death, why can't I sit my kids down while I'm alive and get them to sign a waiver saying they're cool with me giving 50% to charity?
Because the law recognizes coercion.
Oh, right.
If you ask your children to waive their rights while you are still alive, you hold the power of the purse. You can emotionally blackmail them.
Sign this or I'll cut you off completely.
Exactly. By requiring a consent to happen after your death, the heirs are making the decision when the property is already legally guaranteed to them. Their consent is free from undue influence.
The philosophical restraint here is incredible. The law acknowledges individual agency. It gives you that 1/3 to reward a loyal friend or support an adopted child who doesn't legally inherit or give to a charity. But it aggressively subjugates that individual agency to a higher social imperative.
The intergenerational safety net.
Yes. The law dictates that your wealth is not entirely your own. It is the financial backbone of your family structure.
That is the core of it. By forcing 2/3 to the heirs, society prevents a patriarch or matriarch from using their will as a weapon.
You cannot manipulate, threaten, or punish your family through the threat of disinheritance.
It legally guarantees that dependents will not be cast into destitution and forced onto the charity of the state.
So we have this massive 2/3 chunk of the estate that must be divided among the heirs. Who are these people, and how do they divide it? This is where the syllabus gets incredibly mathematical.
It really does. The inheritance structure is primarily divided into 2 main classes. First, we have the Quranic sharers.
Okay, who are they?
These are 12 specific relatives, like the husband, wife, father, mother, daughters, and certain sisters, who have their specific fractional shares explicitly dictated by the text of the Quran.
So their cut is guaranteed.
Yes. For example, A widow might get 18th if there are children, or 14th if there are no children.
They are the first in line. They get their fixed cut of the pie before anyone else looks at the estate. Who is the second class?
The second class is the residuaries, or the asaba.
Asaba.
These are generally the male agnate's relatives connected entirely through the male line, like sons, brothers, or paternal uncles. They do not have a fixed fraction.
What do they get?
Their legal position is to step in and inherit whatever residue is left over after the Quranic sharers have taken their exact fractions.
Got it. So if the sharers take 12 of the estate, the residuaries sweep up the remaining 12.
Exactly.
But this strict fractional system creates a massive mathematical vulnerability. It is the core puzzle of this syllabus.
The deficit problem.
Yes. What happens when you apply the fixed legal fractions to a specific, complicated family tree, and the fractions add up to more than 100%?
This was a genuine crisis in early Islamic jurisprudence. The fixed shares clashed violently with mathematical reality. You cannot distribute an estate that is mathematically insolvent.
Exactly. Let's say an estate has $100,000, but based on who survived the deceased, the strict legal rules say the widow gets 14, two daughters share 23, and the mother gets 16.
Okay, let's do the math.
Right. If you find a common denominator, which would be 12, and add 14, 23, and 16 together, you get 312 plus 812 plus 212. Which equals 1,312.
So you owe 108% of the estate.
You are in deficit. How does the law solve an impossible math problem without violating the legal rights of the heirs?
The solution is the doctrine of all, which translates to increase or proportionate diminution.
Proportionate diminution.
It was a brilliant, pragmatic, legal innovation introduced during the reign of the second caliph, Umar. Instead of arbitrarily deciding which heir gets completely disinherited to make the math work, the law forces a proportional cram down.
A cram down. It's exactly like a corporate restructuring or a stock dilution. Let's map the math out so it makes perfect sense for anyone taking note.
Let's do it.
In our example, the fractions were 312, 812, and 212. The numerators 3, 8, and 2 add up to 13. But the denominator, the base of the estate, is only 12.
Under the doctrine of all, you artificially increase the denominator to match the sum of the numerators. So the base of the estate changes from 12 to 13.
Ah, I see. So the widow's share shrinks from 312 to 313.
Yes.
The daughter's share shrinks from 812 to 813.
Correct.
And the mother's share shrinks from 212 to 213.
Exactly. Mathematically, 313 plus 813 plus 213 equals a perfect 1313, 100% of the estate.
The genius of all is that it recognizes that the fixed fractions weren't intended to guarantee a static dollar amount. They were designed to establish a strict hierarchy of priority.
That's the key right there. Priority.
By diluting everyone proportionally, the legal hierarchy is perfectly preserved. Everyone takes a haircut, but the pain is shared equitably across the entire family structure. No single person bears the brunt of the mathematical anomaly.
It is the pursuit of absolute equitable fairness. But the law must also address the inverse mathematical anomaly. What if the math results in a surplus?
Ah, the opposite problem.
Yes.
Okay.
This is governed by the doctrine of Rad, or the doctrine of return.
Let's set the stage for Rad. We calculate the fixed shares, the estate is distributed, but there is, say, 14 of the estate just sitting there, left over. And, crucially, there are no residuaries, no asaba alive to step in and sweep up the remainder.
Right, the sweepers are missing.
So does the leftover wealth escheat to the state? Does the government just absorb it?
Under strict legal theory, if there is no one left to inherit, it goes to the state treasury, the Beit al-Mal. But the doctrine of Rad, which is heavily favored and rigorously applied, particularly in Shia jurisprudence acts, to prevent state absorption if there are close relatives still alive. The doctrine dictates that the surplus is returned to the Quranic sharers.
So if a mother and a daughter already took their fixed legal fractions, and there is 14 of the estate left over, they don't just split it 50-50.
No, they split it proportionally. The leftover 14 is rebounded back to them in the exact same ratio as their original inheritance.
So if the daughter's original share was twice as large as the mother's, she gets twice as much of the surplus.
Exactly. The wealth remains concentrated within the surviving family nucleus, mathematically expanding to fill the void left by the absent residuaries.
When you put the doctrine of all and the doctrine of Rad next to each other, you see a legal system that acts like a living organism.
It really does.
It breathes. It mathematically expands and contracts to perfectly fit the exact demographic reality of a family on the day of a person's death, ensuring that wealth is dispersed fairly without ever breaking its own foundational rules.
It is an absolute masterclass in dynamic legal drafting.
So let's pull all of this together. We have traversed an incredible amount of jurisprudential territory today.
We really have.
We started with the unyielding, immovable permanence of Waqf, where property is completely divorced from human ownership, locked in a divine vault, and managed by a Mutawalli whose powers are heavily policed by the Waqf Tribunals to prevent corruption.
And we contrasted that absolute permanence with the highly constrained, fluid, and mathematically rigorous mechanics of succession. We saw how the one-third limit on the wasiat prevents the weaponization of inheritance, and how all and rad serve as the ultimate equitable balancers.
If you are listening to this, whether you're trying to master Unit 4 of this syllabus, or you are just fascinated by how different societies engineer their legal systems, the through line is clear.
What's the biggest takeaway for you?
This jurisprudence fundamentally rejects the idea that wealth is a purely individualistic tool. It views property as a mechanism with profound social gravity. It legally enforces a balance between your right to be charitable, your absolute duty to prevent your family from falling into poverty, and the community's right to benefit from permanent institutions.
And I think the most provocative takeaway from this entire exploration lies in that contrast. Look at modern secular property law. We are obsessed with fluidity. Wealth is fleeting, it is hyper-individualized, and it is easily squandered across generations.
Very true.
Now consider the profound, terrifying permanence of the Waqf. I think a crucial question to leave you with is this. What could modern secular legal systems learn from the Islamic concept of the Waqf? What would our societies look like if we had mechanisms to create institutions that were genuinely, undeniably permanent and dedicated solely to the public good, and completely immune to the greed, the bankruptcy, or the changing whims of the generations that follow us?
It makes you wonder how different our cities, our universities, and our hospitals would look if the wealth that built them was truly safe from the vulnerabilities of simple, binary human ownership. Thank you for joining us on this deep dive. Keep questioning the legal architectures around you. Keep dissecting the why behind the what, and we will see you next time.